Good morning, my name is Leandro Mancano and I am lecturer in European Union law at Edinburgh Law School. I would like to thank the editors of Styles and in particular my dear friend Giuseppe Martinico for inviting me to share a few words on my new book, The European Union and the Deprivation of Liberty, a legislative and judicial analysis from the perspective of the individual. The book was published by Hart last year. The Union's action in criminal, asylum and immigration law constitutes one of the fastest growing areas of EU law. These are relatively new fields interacting with more established realms of EU law, such as free movement. The importance of this interplay is apparent from issues constantly under the spotlight of the legal and political debate, such as the sustainability of the Schengen area, the European arrest warrant, the management of migration flows and asylum applications, compliance with fundamental rights and the rule of law within the Union, and the protection of citizenship rights. My research embraces these problems and focuses on the interaction amongst people mobility, the use of public force over the individual, and fundamental rights. In my book, I try to fill a gap in the existing scholarship from a methodological and thematic perspective. The European Union and Deprivation of Liberty examines the EU legislative and judicial approach to deprivation of liberty from the perspective of the following fundamental rights and principles: the principle of legality and proportionality of penalties, the right to liberty, and the principle that criminal penalties must aim for the social reintegration of the offenders. The book measures the relevant EU law against those rights. This constitutes the very core of the relationship between public powers and individual liberty. I analyze the EU law of deprivation of liberty from an EU-specific standpoint by placing and assessing legal phenomena in the context of the unique characteristics of the EU as a legal order. This required a grasp of many areas of EU law beyond those of my specialized expertise, but also of aspects of national law and the law of the European Convention of Human Rights. It brings together the different themes of EU integration, such as the creation of a borderless Europe and the dilemma created by the inroads of EU law into the most intimate pockets of national sovereignty. It is this comprehensive nature of my research that represents the cornerstone of my approach to issues of individual protection in Europe. My contribution creates a new analytical framework to unpack the problems caused by the expansion of EU law into remits traditionally considered the exclusive prerogative of the states. It provides a new vocabulary to discuss how free movement relates to the law of coercive measures at EU level, thereby overcoming the fragmented approach currently existing in the scholarship. For example, I argue that we need to think of the EU law of deprivation of liberty in terms of forced movement as opposed and in relation to free movement. So, measures of forced movement such as the European arrest warrant or the Dublin regulation in asylum law are in place to protect the sustainability of the EU as a borderless area, or, in other words, to preserve the safe exercise of free movement by law-abiding EU citizens and businesses. Another key feature of the EU law of deprivation of liberty is the combined operation of static rules, so establishing a level playing field approximating standards and legal remedies across the Union, with dynamic rules governing the mechanism of transfer of persons within and out with the EU. Again, the European arrest warrant, the Dublin regulation, but also the return directive and expulsion of EU citizens from the member state where they have moved to. The analysis shows that the ultimate goal of the EU law of deprivation of liberty is the creation and preservation of the EU as a borderless area. The integrated approach adopted in the book explains how different legal phenomena connected to deprivation of liberty have come into being in EU law. This research overall devises and advocates for legal solutions tailored to the specific characteristics of the EU as a legal order.